Good evening, everyone. We'll just give it a moment to let more colleagues come in from the virtual waiting room. Excellent. Well, good evening, everyone. Thank you very much for joining the team at 39 Essex Chambers for this webinar to discuss the Children's Wellbeing and Schools Bill that's currently before Parliament, in particular, the provisions of that bill which relate to children not in school. And we've subtitled the session tonight, Benefits, Threats and Challenges. We want to look in the hour we have available at these clauses from all angles. And I'm delighted to be joined by three colleagues who've looked at a clause each of the provisions in relation to children not in school, Tom Tarbury, Anna Layden and Santosh Carvalho. I'm going to just start very briefly by making sure that everyone knows what it is that we're talking about this evening. I'm going to ask colleagues in Chambers to stop sharing for a second so I can, thank you guys, so I can share my screen. We're in various places physically, so this requires a little bit of virtual jumping around. The Children's Wellbeing in Schools Bill, as many of you will know, is currently before the House of Lords. So the version of the bill that we're talking about tonight is HL Bill 84, as brought from the Commons on the 19th of March, and very shortly the consideration by their lordships of the bill will commence substantively in the Lords. This is what the bill currently looks like. And the provisions in relation to children who are out of school are found here in Part 2. So we see that within Part 2 of the bill, there are provisions in relation to breakfast clubs, school uniform, and then these clauses here in relation to children not in school. And so tonight, Eleanor is going to be speaking to Clause 30, local authority consent for withdrawal of certain children from school. Santosh, if I get it right, is going to speak to registration, the requirements in relation to registration, and Tom is going to speak to school attendance orders. Each of my esteemed colleagues will introduce their topic and go through in some detail what the key implications are of the proposed changes to the law. What I thought might be helpful at the outset is just to look at the policy summary. There's been a lot produced about this bill, which does give us some guidance as to what the intention is behind the legislation. And this policy summary from December, updated in March, tells us at page 79 what the proposed measures are for children not in school and why they are being put forward for enactment. So we see that this measure, well, it's actually a series of measures, helps ensure that children not in school are receiving a suitable education and are safe. So that's the policy intention in summary, is to ensure that children not in school are receiving a suitable education and are safe. And I'm going to suggest as an overall point that what this bill would mark, if it becomes an act, is a really quite striking rebalancing of the playing field in relation to the responsibility for ensuring those outcomes, but taking that to an extent away from parents and putting it in the hands of the state. So whereas it might be said that prior to this bill, the primary obligation, certainly in relation to receiving a suitable education, rests with parents, and it might be said that there's a joint obligation in relation to children not in school for safety and well-being between parents and local authorities. It's very clear that the intention is to tip the balance here towards the local authority having control over certain situations which are being proposed as being particularly risky or particularly likely to result in a child not receiving a suitable education. So the specific measures that may, and of course we say may because this is still a bill, not an act, become law. First of all, compulsory children not in school registers in each local authority area, a duty on local authorities to provide support for the first time to parents of children on those registers. Changes to the school attendance order process to make it more efficient. When we get to Tom's talk, I think we will understand that that's rather a glib, it might be said, shorthand for what's actually being done in relation to school attendance orders. A requirement whereby parents of some children for whom there are existing safeguarding concerns or attend special schools, that's very important, two distinct subgroups there, that they will need local authority consent to home, the parents will need local authority consent to home educate. And where children subject to some child protection processes already being home educated, the local authority will be able to require them to attend school. And then a requirement for local authorities to consider the home and other learning environments when determining whether children should be required to attend school. So much more intrusive involvement of the local authority in the question of whether at least certain children ought to be home educated. A real change there, I would suggest. Why? Why is this being put forward? So the summary that's given here of the following 4 paragraphs, I think is very interesting in terms of understanding the competing imperatives. So first of all, recognition that all parents have a legal responsibility to ensure their child receives a suitable, efficient, full-time education. Section 7 of the Education Act. Most parents, it said, choose to fulfill this responsibility by ensuring their child regularly attends school, but some choose to educate them otherwise. So immediately it's identified that we're dealing with a minority here, for example, by home educating them. A statement that's important, I think, that most parents who choose to home educate do so in their children's best interests, and many home educated children receive a suitable education that supports them to achieve and thrive. But there's a concern about the number of children in home education accelerating since the COVID-19 pandemic, and the reason for that, including mental health concerns or special educational needs, additional needs. A suggestion that in some instances, parents may not be well equipped to provide a suitable education, and some of those children may also be at risk of harm. Some children have been seriously harmed or died due to abuse or neglect whilst not in school, or having been removed from school for the purposes of home education, it is said, and children in social care, including those on child protection plans, also experience poorer educational outcomes. And so it's suggested that education settings can be a protective factor for children, particularly those at risk of harm. And the overriding policy behind this bill then is that if enacted, Parliament is saying it's a good thing for children to be in school generally. Where children are not at school, that gives rise to concerns, and we want the state to be more involved in those cases. I'm not going to engage or suggest we engage tonight in the debate about whether this is a good idea or not. We're here to talk about the law, but it is important to understand the policy behind the law, and that clearly is the policy, that there is a risk associated with home education that needs to be mitigated and managed. So that's all I was going to say by way of general introduction. Just to introduce the session a little more, we have the usual, I hope now, familiar Q&A function in Zoom, which allows you to post questions in the Q&A box below, and we will seek to answer those either in writing or orally. We'll look at the questions after each of the presentations and perhaps have a longer session at the end. The slides will be circulated, and we will ensure that any question that's put is not identified to any particular individual when we discuss it. So with those brief introductory thoughts, I'm going to pass over to Eleanor now to talk about Clause 30. And I should say, although it sounds quite simple for my colleagues to talk about Clause 30, Clause 31, these clauses actually contain quite a large amount of material in proposed new sections of amending acts. So Eleanor, I'll pass over to you.
Thanks very much, Steve, for that introduction. Very helpful introduction, very helpful policy summary of what the bill is trying to achieve. So I'm going to move quite quickly on to Clause 30 from the first slide, which is similarly setting out the context. So as Steve's highlighted, the cohort of children who are not in school is a diverse cohort. It includes many children with special educational needs, many children from disadvantaged backgrounds, and a small minority of some children who are at risk of serious harm. So the task of that complexity is recognised clearly in the policy summary to the bill and other policy papers that have come out in the last few years. The task of the bill is how do you regulate for that diverse cohort? I've put on the slides a couple of key provisions of the existing legal framework. So the Section 7 duty on parents to ensure their child's full-time suitable education, whether at school or not. And there's also the Section 436A duty on local authorities to make arrangements to enable them to establish the identities of children in their area who are not in school so far as possible. And what the findings of the Children's Commissioner have been is that local authorities have previously been ill-equipped to discharge that duty effectively. So moving on to so the key implications of the bill in what Steve has said is a striking rebalancing of the balance of power, perhaps between parents and local authorities. We'll see that there are far more local authority powers and oversight, in particular the consent requirement, which I'm going to touch on, and the register, which Santosh is going to talk about, and correspondingly less parental freedom when withdrawing certain categories of children from school, and also more duties on parents and third-party providers. So moving on to clause 30, I've set out here the beginning of the provision, and we can see there in sum that a parent of a relevant child must now obtain a local authority's consent to withdraw a child from school and home educate them. And essentially relevant children are of compulsory school age, registered pupils of the school, and one of two conditions is met, which I'll come on to in a moment. So against the background where we know that local authorities have been struggling to discharge their duty to identify children not in school, we can see, however, that what's proposed here goes beyond a duty, for example, to notify the local authority that you intend to withdraw your child from school, but actually a requirement to obtain the local authority's consent in certain circumstances. So it is the view of many parents that this is a departure from the position under Section 7, which essentially enables parents to make that decision in the exercise of their parental responsibility. So moving on to the two categories of children affected, I'll start with children who meet condition B, and those are essentially children where there are Section 47 safeguarding inquiries underway or action is actually being taken under Section 47, so children at risk of harm. And there is a May 2024 Child Safeguarding Practice Review paper that sets out the rationale for this. It's the addition of condition A to the bill that has caused the real controversy, and this essentially imposes a requirement for local authority consent to withdraw children who are in all variety of special schools under arrangements made by a local authority. And Steve's briefly gone through the government's justification for including this cohort of children into the consent requirement. Those interested can also see the explanatory notes, paragraphs 38 and 41, which sets out the government's rationale that parents of children with complex needs who are increasingly choosing to home educate may not always be well prepared or equipped to provide them with a suitable education. At 41, there's a concern that the removal of the support available in the special school could in some cases result in safeguarding issues or in a child not receiving a suitable education. Although you might say that if the former is an issue, then condition B would be met. It's worth noting that government have declined to further extend the consent requirement to make a requirement for local authority consent to withdraw any child receiving support or services under Section 17 of the Children Act. The government reason for that was that that would be disproportionate and undermine a non-stigmatising approach by which families are encouraged to seek support under Section 17. There's a question to be asked about the extent to which that approach and that justification is consistent with the justifications for including the cohort of children in special schools under local authority arrangements. So this provision, in particular, subsection 3, condition A, raises some serious issues about whether this provision may have a differential impact on certain categories of children and whether any such impact is justifiable. Moving on briefly, I'm going to touch very briefly on proposed subsection 5. This is a new obligation on schools that where a school proprietor is notified by a parent of their intention to withdraw a child, they must notify the local authority. I believe previously the position was that a school would only have to notify a local authority when they're actually removing a child's name from the register, rather than when notifying a parent of their intention to withdraw. So if a parent seeks consent to withdraw their child from school, the next question is, what is the determination process? And subsections 6 to 7 tell us, on an application for consent to withdraw, the authority must decide without undue delay whether to grant consent. And then there's a structured process here for the decision they must reach. They must generally grant consent, but they must refuse it. It's not expressed to be discretionary, although it's essentially a judgment for the local authority as to whether they think it would be in the child's best interests to receive education by attending school regularly. And they must also refuse consent if they consider no suitable arrangements have been made for EOTAS. So just breaking that down, sorry, Santos, we go back a slide, thank you. Just breaking that down, the decision must be made without undue delay. No specific timeline or deadline is given. And that has obvious implications for children who are struggling with school. I mean, under either condition A or condition B, either for reasons related to special educational needs or mental health or well-being. If a child is really struggling to attend school, but a local authority decision is not forthcoming, that poses issues for parents who may be seeking to effectively withdraw their child, but may have concerns about being pursued for non-attendance. So there's a question there about the time frame for these decisions. Similarly, the requirement to show that suitable arrangements have already been made for EOTAS provision, which is a far from easy task, has implications for children where parents want to withdraw them in circumstances that seem urgent in respect to the child's well-being. Just briefly, finally, to note, under the technicalities of this provision, these applications should usually be made by parents, but a school can do it only on the parent's behalf and with the parent's consent. So essentially, if a parent wants to make that application but can't do it themselves, rather than the school being empowered to always make an application in its own right, if that makes sense. The next subsection very briefly provides, this is also one for schools to watch, provides that the regulations under section 434 of the Education Act must essentially be amended to reflect what's proposed in clause 30. So if this passes, schools can expect there to be consequential amendments to the school attendance registration regulations. Moving forward to the appeal process, once an application for consent is made, there are slightly different processes depending on whether you're appealing a decision to grant consent to withdraw or to refuse consent to withdraw. But essentially, it's for parents in England to appeal to the Secretary of State or parents in relation to Wales to appeal to the Welsh ministers. First point to note there is that places a burden on parents, and also the clause as currently drafted doesn't particularise a mechanism for the appeal process. So how are you going to appeal? It's crucial, I would suggest, that any appeal mechanism should be easy to access and easy for parents to understand. The other point to note is that if a parent is appealing a decision to grant consent, if you look at 10b, the Secretary of State's powers are to either uphold the decision to grant consent to withdraw or refer it back to the local authority for redetermination. If you're appealing a decision to refuse consent to withdraw, under 11b, the Secretary of State may either determine the matter for themselves or refer it back to redetermination. The rationale for this is set out in the explanatory notes at 251 and has to do with the mechanism for how the school attendance audit process works. I have to confess, I'm not fully on top of it, but the rationale for that difference is set out in the explanatory notes. One quick further point in relation to the appeal process: if a local authority refuses consent for a child to withdraw from school, and a parent makes a fresh application, the local authority is not required to make a new decision until 6 months has passed since the date of the previous application. So that's one for parents to be very much aware of. If you are refused consent on a first application, you may need to wait 6 months. So it shows the importance of getting that application right. So that's clause 30. I'm going to hand over to Santosh for clause 31.
Thanks very much, Eleanor.
Just before you do, Santosh, Eleanor, there are just a couple of points that have come in. I think it'd be quite helpful to pick up right now, if that's okay. So, and they both relate to the condition in relation to child protection concerns. The first point that's being flagged is whether that impacts on any child who'd be seeking support under Section 17 in relation as a child in need, or any parent who's seeking support in that regard. And the short answer to that is no, isn't it? The threshold for falling into that condition is that there's at least live child protection investigations.
Yes, that's right, Steve. So yeah, the condition B relates only to where there are currently inquiries or other action being taken under Section 47.
So then the second point then about that is that, of course, the threshold for a Section 47 investigation isn't set particularly high, and parents are concerned that local authorities will have an investigation that may not be completed very quickly, which then allows them, or in fact mandates, that they require consent to withdraw the child from school. What can be done about that, do we think, within the scheme that's being put forward in the bill? It's really about this point on undue delay, isn't it, and how that's interpreted, I think.
Yeah, I mean, it's difficult because that may be a low threshold, but the clause doesn't allow for the sort of discretion in terms of the requirement to get local authority consent in those circumstances.
That's right. And it's interesting to think whether parliamentarians might consider whether there ought to be a degree of discretion here, or if it's appropriate to require local authorities to, or require consent to be obtained in every case that falls within one of the conditions. But that's perhaps a question for another place, shall we say. Thanks very much, Eleanor, for that really helpful overview. Santosh, would you like to move on now to clause 31, the registration requirement?
Thank you very much, Steve. In the interest of time, I propose to just cover a subsection of the provisions in clause 31, which I'll hope will be of some interest to this audience. Clause 31 operates in some ways in the same way as clause 30, in that it's a lot of amendments to the Education Act over and above the existing provisions that are already found there. So the first point to consider is the local authority's duty to maintain a register in respect of children who are not in school. There are three conditions that trigger this authority. It's a mandatory duty. The first, and this is found in section 436B2, and it sets out the three conditions that follow. The first is that the child lives in that local authority area. The second is that the child is of compulsory school age. Now, the third condition is worth just spending a little bit of time on. So firstly, let's start with subsection 5A, and there's reference to the term registered in two different places. So child is not a registered pupil or a student registered at a relevant school. So the first part of that clause, child is not a registered pupil, is referring to the registration within this new clause. The second part, student registered at a relevant school, appears to be referencing registration in respect of enrollment. So a child is already in that school. So if neither of those conditions are satisfied, that is to say, they're not on this register that the clause proposes, and they're not enrolled or registered with the school, they become someone the local authority must register. My view is that this will perhaps, it's difficult to quantify exactly, but it will perhaps be one of the largest classes of children not in school captured by that particular clause. 5B is slightly different in that this looks at a registered pupil, again, the same terms, we come back to registered used in two different places. So a child is on this register, introduced by clause 31, or a child who's enrolled and registered at a school, but, and then you see the qualifications in respect of an agreement with the school or the proprietor in terms of how that education will be provided. This is perhaps where children with special education needs, not all of them, but some of them, will be captured, in the sense that some may have been withdrawn from school for a period of time where it was felt that their needs were better met to a partial or a fuller degree at home, or it might be someone with special education needs seeking to transition back into school and they're not quite made up in terms of the number of hours. The last subsection there, referencing subsection 7D, which is not on the slide, refers to an institution within the further education sector that provides secondary education suitable to the requirements of children who've attained the age of 14 years. This will capture some children who are receiving potentially vocational training, and they're doing so on a part-time or less than part-time basis. All of those requirements in section 436B refer to a relevant school in judging whether a child should be on the register. I just want to emphasize the point that relevant school is defined very broadly. There is a list in subsection 7 that casts the net wide. It includes maintained schools, academy schools, independent schools, and non-maintained special schools as well. Now, the local authority has that duty to maintain the register, which leads us to our next question, which is what should this register contain? That's where we turn to section 436C. Now, the minimum subset of information that the local authority must capture is found in subsection 1. It's a mandatory duty, hence the reference to must. The first three, A to C, the first three bits of information are less controversial. Condition D, or the information criterion D, is one that's generated slightly more controversy, so that the local authority must capture the amount of time a child spends receiving education from each parent. We don't have a definition of education in this clause. It may follow in guidance, but we know that courts have interpreted education rather broadly in the past. Now, it's not immediately clear, or one might say it's debatable, the extent to which the policy aims, welfare of the child, educational outcomes, are advanced by knowing the unit of time or the amount of time spent in education by each parent. Notably, this minimum subset of information does not require the substance of that education to be disclosed. So it seeks the amount of time, which is the parent spends 10 hours or 12 hours or however so defined, but not 10 hours on music or languages or whatever else it might be. The other bit of mandatory minimum subset of information that the register must capture is in E, and this is another area of controversy. I've emphasized a few different terms, and I'll go to them shortly, but the first one to note is education from a person other than their parent. On a plain reading of that phrase, it may capture a fairly significant amount of activity in a child's life. Lessons provided by a private tutor in languages or maths or whatever it might be, organized sports perhaps, even Sunday school attendance for those more religiously inclined. The other matter to capture is in 4. As you can see, it's the total amount of time that the child spends in such education provided by someone other than the parent, but also the amount of that time spent without the parent being actively involved. There's no guidance at this stage issued under this clause, although provision has been made for it to be issued. I hope active involvement, if it remains in the clause, it survives going forward, some guidance is provided for that, because to me it seems rather difficult for a parent to calibrate, firstly, what does active involvement mean and what the tipping point between active and passive is. To use a very crude example, if one takes their child to a structured sporting event, it might be a football class, or it might be any other sport of that kind, it's not immediately clear to me if standing on the sideline and cheering is active involvement, or if someone's like me and scrolling their phone intermittently, whether that falls into passive. this is where guidance would be rather helpful. Now, the other subset of information that must be on the register, this is a mandatory duty on the local authority, but qualified. It's qualified to the extent the local authority either possesses that information or through reasonable efforts can obtain it. And if they can either possess it or they can obtain it with reasonable efforts, they must capture it in the register. The list is very long under the subsection, under subsection 2. I don't propose to go through all of it. I'll just highlight 3 points that I think are worth noting. The first is the reference to child's protected characteristics within the meaning of the Equality Act. Now, it's immediately apparent that at an aggregated level, there are some benefits to the state from capturing this information. It might be an aid to policy making. But at an individual level, I can quite appreciate a parent's concern that a local authority is making, on the assumption they don't have that information, is making some reasonable inquiries to obtain it. Now, again, it's debatable the extent to which those twin policy aims that Steve outlined, child's welfare and educational outcomes, are improved by a local authority, for instance, seeking to ascertain the sexual orientation of a child. The second point is the reasons why the child, so we move on to H, the reasons why the child meets condition C in the eligibility to fall within the register. In simple terms, that is why the child is not attending school. These reasons must be captured. Now, an interesting area of examination of a potential legal challenge is what if the local authority, for instance, took refusal by a parent or the reasons given by a parent as to the child attending or rather not attending school, they took that as a reason to issue a notice of a school attendance order. It may engage Article 2, Protocol 1 rights, it may engage various other convention rights. My colleague Tom will cover the mechanics of school attendance order, but it's worth flagging, even on a case-by-case basis, there might be tension in terms of the parent's justification for the child being at home or not in school and the school attendance order. And the last point to make about the register in this qualified duty of the local authority is that they've got quite a lot of discretion under subsection 3 to capture any information that they consider appropriate. Now, stepping back for a moment, there's a lot of information to capture. The first part is a mandatory duty, that minimum subset that I spoke about, in and of itself is a lot. But then the qualified duty is also a lot of information. So where does the local authority get this from? Well, they're reliant to a very large extent on parents. So the first duty on parents to provide information to support the register, it comes from section 436D. Now, there's a temporal element to 436D. The first bit is a parent of a child is eligible to be registered. Now, let's fast forward a few months from now, potentially a year from now. Let's assume this bill becomes an act of parliament. At that moment in time, no child is on this register. At that moment, a parent has to, if their child is eligible, they have to inform the local authority the child is eligible and provide that minimum subset of information that the local authority is required to capture. It's important to emphasize that this is only in relation to that minimum subset of information. Therefore, there's no duty to provide the local authority with the child's protected characteristics, nor is there a duty to explain why the child is not attending school under this provision. Under subsection 2, we move on in the temporal analysis or the temporal description. This is a point at which the child is registered under section 436B. Now, once they're registered, the local authority has the power or the right to request the parent to provide that minimum subset of information. Concurrently, the parents are under an ongoing obligation to update the local authority with any changes to that information. And then under C, of course, there's a registration, there's a point if the child ceases to be registered. Now, I just want to note the point about that continuing duty. That can in some circumstances be quite an onerous obligation potentially. I think if we go back to that information about the third party provider providing the education, any changes to the identity of that provider, the quantity of time spent with that provider, or even the type of education being provided, all might trigger this obligation to provide information on an ongoing basis. What's also curious about the difference between D2 and D1 is that D2, once the child is registered, the local authority has a power to compel the parent to provide that information. But before the child is registered, there is no such power. So at the point the child is eligible for registration, but is not actually on the register, there is a duty on parents, of course, to provide that information, but there is nothing in this clause that the local authority has by way of a stick, quote unquote, to compel the parent to provide that. In terms of time for compliance, it's defined by a relevant period. So what is this relevant period? It all turns on that temporal description again. So once the child is eligible for registration and they're not yet registered, we're within the bounds of 4A. So it's a period of 14 days from the point at which the child becomes eligible. After the child is eligible and is registered, we get to 4B. Now, 4B is once the local authority says, please provide me with that information, that request must specify or give the parents no less than 15 days to respond. And then in terms of the ongoing duty, in terms of the parent to update the register, that's 15 days from when they become aware of a change. Now, what if a parent refuses to comply, fails to comply for whatever reason? What are the consequences? Clause 31 itself does not provide any direct consequences. So there's no fine, there's no statutory offense created. However, the failure to provide this information for whatever reason is a factor in the local authority making a decision to issue a school attendance order under clause 32. My colleague Tom will cover that in some detail. Very, very briefly, there are also duties of disclosure on third-party providers of that education. However, that is only where the local authority has a reasonable belief. Now, this is section 436E. I want to just look at 4 terms very quickly. Firstly, reasonable belief. So this is an objective standard. The local authority must have some grounds for forming their belief that a child is being provided out-of-school education for more than a prescribed amount of time. So firstly, out-of-school education, that is defined later in this subsection, fairly broadly, any program or course of education or any other kind of structured education. And then prescribed amount of time, also defined in this subsection. The Secretary of State has the power to make regulations to prescribe what that time is, and it can be defined by hours in a week, any other period, or any other way. Again, we come back to the difficulties around active involvement, and I suggest it'll be just as difficult for the local authority in making that decision as it would for a parent. In terms of what this third-party provider has to come back with, only one point I wish to emphasize here. So we've got 2 requirements. So the first is the notice that comes to this third-party requirement in respect of a child. So there's a particular child that will be mentioned in that notice, and there has to be a response in respect to that child. But again, curiously, subsection B, on one reading anyway, seems to suggest if a request is made in respect of one child, under subsection B, that education provider has to reply in respect of all children in respect of whom they've provided such education. Now, as I said, this is one reading, and this one reading might suggest it might also include children who are attending school. So there's no qualification to that requirement in B anyway. I'm going to skip over the provisions of section 436F, which is how this information is used, and also 436G in the interest of time. As Steve said, these slides will be made available to you. So what might a challenge to clause 31 look like? I'm just going to provide the basic building blocks, and I'm going to stay as neutral as possible in terms of my own view of what the likely outcome might be. So some preliminary points about challenging the compatibility of what will be primary legislation once it becomes an act. The court does have this power under Section 4 of the Human Rights Act, but statistically, it's exercised this power very, very sparingly. So between 1998, or 2000 rather, when the Human Rights Act came into force, and 2022, the court made 46 such declarations, of which 6 were overturned on appeal. It's not enough to show that the measure will lead to a breach of convention rights in certain cases or most cases. You see the citation there. In essence, it is a measure that must be incapable of application in almost all cases, or certainly all cases. So the first stage of the analysis is the engagement or the interference with these rights. Steve rightly, in my view, described this clause as a whole, or the bill as a whole, in shifting or striking rebalancing of the relationship between a parent and the state in respect of regulating education of a child. If we think of the information that is sought, even just the minimum subset of information sought from parents, it's quite a shift in the relationship between the state and parent in terms of the relationship with the child. Therefore, private life and family life rights are probably engaged. Article 14, it's a parasitic right. You need to identify a protected characteristic. Home-schooled children and home-educating parents are not in and of themselves a protected characteristic. However, the article disallows unjustified differential treatment on the basis of status. Can it be argued that homeschooled children or home-educated parents are a particular status? Can it be argued that the bill itself creates the status? Article 9 raises some very stark questions. The law seems to have the effect of requiring a citizen to disclose details of the religious practice to a state. A devout Catholic parent might send their child to a Sunday school. Under 4361E, it might require disclosure of the parish, the name of the parish priest, the name of the volunteers running Sunday school, and of course the ongoing duty to inform the local authority of any changes to the same. And lastly, there's also a potential implication of Article 2 of Protocol 1. In terms of legitimate aim, Steve highlighted those. Certainly, the welfare of children is a compelling policy objective for the state to have. Is there a rational nexus between the measure and the aim? I highlighted some areas of potential debate of where that might be queried. I'll turn to the less restrictive methods. Perhaps this is where the crux of the challenge might lie. In effect, this is a blanket duty of parents under Section 436D. There's no requirement for the local authority to have any grounds to believe the child is at risk of harm or unsuitable education to demand that information. An interesting contrast is found within Clause 31 itself. The local authority can only seek disclosure from a third-party provider subject to their reasonable belief. Both provisions are pursuing the same legitimate aims, but the third-party provider is provided with the benefit of the doubt. One could argue, why couldn't the duty to maintain the register arise only when there's a reasonable belief of harm or unsuitable education? Now, the last part of the proportionality analysis will require weighing the restrictions against the right. At this point, I'll highlight a few points. Reasonable minds may disagree on this. There are already published legal opinions from very eminent legal jurists on this point who come to differing conclusions. Proportionality analysis often weigh incommensurate matters. Is it a value judgment in this case of weighing risk of harm to some children and interference with convention rights of all of homeschool children and parents? The reason to stress this point is because deference to Parliament in areas of social and moral controversy has been a feature of the case law in compatibility challenges. I've ran slightly over my allotted time, so I can only apologize for that. I'll stop there in respect of Clause 31.
Thanks very much, Santosh. That was really excellent. I'm going to move straight on to Tom now, please. And if we've got time, I may come back to some questions on Clause 31. So over to you, please, Tom.
Thanks, Steve. I'm going to try and share these slides. There we go. Hopefully you can see some slides there. Thumbs up, great. So as Santosh, Eleanor, Steve have all said, I'm going to deal with the last of the clauses, Clause 32 of the bill, school attendance orders. So Clause 32, little intro there on that slide. But actually, it's a whole host of new sections that will be inserted. Before I look at them and what it'll all entail and the changes, just to sort of set up the context. And I imagine lots of people in the audience will know about the current regime, but to really sort of get our heads around what's changed and the ramifications, helpful to take stock of what the law currently is. So currently in the same Act, Education Act 96, Section 437, a school attendance order must be served if it appears to an authority that a child of compulsory school age isn't receiving suitable education, whether at school or otherwise. And the authority then serves a notice requiring that child's parent to satisfy them that in fact they were receiving suitable education at school or otherwise. And then, having been so notified, the parent fails to satisfy the authority that the child is in fact receiving suitable education at school or otherwise, and in the authority's opinion, it's expedient that the child should attend school. And this, of course, once enforced, remains in place unless revoked, or on any prosecution there's an acquittal. But if on the prosecution succeeds, the person's found guilty, it is sort of an offence with a fine going up to level 3 on the scale, which is £1,000. I mention that detail because it's one of the changes we'll see as to the size of the fine. And you may, as I say, request revocation of the extant order. The authority is obliged to comply with that request unless they disagree as to whether otherwise the EOTAS arrangements are satisfactory. And if they do, then the aggrieved parent, so that's the word actually used by the statute, the aggrieved parent may refer the question of whether the arrangements, the home education arrangements, say, are satisfactory to the Secretary of State, who may give such direction, determining the question as they see fit. Now, into that sort of nutshell picture comes the current bill. And in Schedule 2, in the consequential amendments, it will essentially remove all of those provisions. It all goes. And in its place, there will be a new sections 436H to 436 goes to 436S. But despite that massive overhaul, the changes are quite specific. So just by way of sort of snapshot of it, the explanatory notes of paragraph 39 helpfully, so even if you find my talk slightly sort of rambling, a sort of nicely condensed version is in the explanatory notes, which is at paragraph 39. These are the sort of highlight changes that are being made to the school attendance order regime. So introducing statutory timeframes for issuing and processing school attendance orders. So we'll come on to see how, once the sort of grounds are established and so on in terms of the procedure, there's now lots of mention of as soon as possible, basically, and within 5 days for the various stages of service. So the local authority can't sort of stall and fail to get round to it. Secondly, it will now apply to academies too, with particular relevance for if an order is made and it can name an academy, and the academy will have a duty to admit. So that extends a process that previously only applied to maintained schools. Making it an offence for parents to withdraw a child subject to an order from school without following proper procedure, and increasing the maximum penalty for breaching an SAO. So quite pithy, but actually there's a lot more to it, as we're now about to see. And I'm going to start with the grounds. It begins in 436H, and as you can see, the local authority must serve a preliminary notice. So again, it begins with a preliminary notice, obviously for procedural fairness reasons, on a child's parents in relation to a child for whom the authority is responsible, if it appears to the authority. So appears sort of almost low threshold from the sort of Children's Act context, that the child is of compulsory school age and either condition A or condition B is met. And then there's a discretionary pair of grounds too, which are C and D. So I'm going to go through conditions A, B, C, and D in order. A won't take very long because it's essentially like the current regime. So currently there's this one ground and it's now condition A. The child's not receiving suitable education, either by regular attendance at school or otherwise. Condition B is entirely new. It's the one that been much mentioned in discussion of it in the news and so on. It's the child protection ground. So if a Section 47 inquiry is going on or child protection action is going on, then if the child's not in school, then there's this test of would it be in the child's best interest for them to receive education at school rather than at home. The Children's Commissioner's briefing for MPs on the bill mentions, in relation to this specific new ground, the Sarah Sharif case, which was the 10-year-old murdered after being taken out of school to be educated at home. So we can see the sort of obvious statutory intent for that one. But to turn to condition C, slightly more complicated and problematic, as we'll see. Santosh has sort of touched on why, and I'm going to sort of continue within it in the sort of SAO context. So this is the first of the discretionary grounds. The authority may serve a school attendance order preliminary notice on the parent, citing condition C if three elements are established. First is that the child is an eligible child, such as Santosh describes, so eligible to be included in this new register, i.e. Compulsory school age, not currently registered at a school, and have either arranged EOTAS or temporarily absent. The local authority has, quote, asked the parent for information under 436D, and the parent has failed to provide that information before the end of the period. Now, slightly banal observation is that this effectively is ancillary to the new information gathering procedure that Santosh mentions. It's sort of, it looks a bit like an enforcement mechanism. We'll hit you with an SAO if you don't get back to us and provide the information. Also, it's not particularly new necessarily, because there's already been a de facto non-statutory basis for finding that suitable education is not being received, that a parent just doesn't provide any information on what they're providing at home. And we see that in the current EFE statutory guidance to local authorities on elective home education, 6.5, so it's the current slide. It would normally be justifiable for the authority to conclude the child does not appear to be receiving suitable education. And C2610, local authorities considering whether they should serve a 4371 notice in a specific case should note that current case law means that a refusal by parents to provide any information in response to informal inquiries will in most cases mean that the authority has a duty to serve a notice. And the case law mentioned is Phillips and Brown from 1980. If parents give no information or adopt the course adopted by Mr. Phillips, merely stating that they are discharging their duty without giving any details of how they're doing so, LEA will have to consider and decide whether it appears to it the parents are in breach of Section 36. But despite that, the sort of obvious premise of enforcing the information request and the obvious sort of common law, case law ground for it to build on, there is a potential drafting issue that's gone on here. So as I mentioned, one of the conditions, one of the elements rather of condition C is that the local authorities asked the child's parent for information under 436D1. So I'll just go back to that to show you. So if you see B there, so it has asked under 43D1. But if we look at 43D1, parent of a child who is eligible to be registered by an authority must inform the authority if the child's eligible, must provide the authority with any information referred to. There's nothing in that that enables an authority to make a request. It's not a request provision, it's a sort of general rolling duty on the parent to supply information to the authority. And almost to underline the point, in the sort of next subparagraph down in 436D, we see an actual request provision. So for the very different scenario, so it's just building on what my colleague Santosh has mentioned. So a stage on for a child who is already registered, then the authority can make a request, presumably if they want to sort of check something, or they've got cause to doubt something, or for whatever reason, they have a request power there, as you can see. So on one view, there are some problems here. Condition C, of one of the third ground, if you like, for making an order under the new regime, is otiose, because there cannot have been the request that it is its precondition can't have happened. Secondly, an authority who tried to make a request reliant on 43D1, so informed by the provision on condition C, may be acting ultra vires. And thirdly, speaking about what I'm talking about, the school attendance orders context, if the authority sent a parent a preliminary notice threatening an order reliant on condition C, you could have the situation where that notice says, we're relying on condition C, we sent you a 43D1 request, you failed to respond, and the parent replied, it's not possible for you to have done so, you can't have done so, because there's no request power in 43D1. Of course, the courts might say that it's surely implied that the authority might use 43D1 to make a request, but not necessarily. And when we're here ultimately in the sort of context of a potential sort of penal provision for if you sort of disobey, there arguably ought to be more clarity than that. And the court might say, well, we all know about the existing case law, etc. We know what it's trying to say. But the parent might say, well, that common law is less relevant now because Parliament has come in and the provision now occupies the space. And Parliament has chosen certain limits to the power and certain parameters, and those are the extent of it. And it's impermissible to sort of supplement it with the common law. So I'm not going to say that I foresee JRs in this context, but I just think there might be an issue here. But as Steve mentioned, it hasn't finished in Parliament yet, and it may be that is ironed out. Second issue in relation to condition C, which as you can see is a lot more fun than A and B for purposes of this sort of talk, anyway, things to talk about, is that the nature of the information that may be requested, and that a condition C order or preliminary notice may be used to enforce. So 436H6B, the authority has asked the child's parent for information under 436B, 436D1. And the issue here is as to the nature of the information, and this is again borrowing or repeating some of what Santosh has said. So as to the information that may be requested, so 436D1 is provide the authority with any of the information referred to in 436(1) that the parent has. We look at 436(1). A register under section 436B must contain the following information with respect to a child registered in it. Some stuff that's quite banal and almost mimics the existing school registration regulations. But this oddity at D, the amount of time that the child spends receiving education from each parent of the child. Now, I can't presently see exactly why that would be useful or much less relevant to an authority's purposes in this context. It might be possible to imagine that certain parents who had convictions or are on some sort of register, the authority may want to know precisely how much of the education that individual is involved in. But to sort of, as a matter of course, ask every family as to how they allocate the extent of home education doesn't seem rationally connected, to use the language of proportionality, because this is obviously engages Article 8, to the premise and aim of making such an order.
I need to jump in there. We are actually at time now. Do you want to just wrap up with any final thoughts?
Well, the final thought would be, so there's of course condition D2. The procedure is much the same, although I've mentioned it's much expedited in a focused timetable. It's still an offence, albeit the penalty now includes potential imprisonment. The fine has gone up to level 4, so £2,500. But yes, I mean, so I think that the sort of conclusive point is that, to return to the explanatory notes, is that whilst it can be sort of quite pithily reduced by those notes, actually there's quite a lot that's going on here, and some of it potentially problematic for the authorities that have to use it and the parents that have to be on the receiving end of it.
So thank you ever so much, and thank you also to Eleanor and Santosh as well. We've had lots of questions going on in the Q&A. I've done my best to answer as many of them in writing as I could. We haven't got time to take any more already, I'm afraid, and that does reflect the fact that within these seemingly short 3 clauses, there is a huge amount of very important legal innovation. I would suggest that we need to come back and do this again once the bill's gone through, and we're actually talking about the new act, which one assumes have some kind of lead-in time. So there may be an opportunity for us to go through this again by reference to the final legislation. But there is, of course, an opportunity for the bill to be amended in the Lords imminently. And I know a number of people involved in tonight and others are interested in seeing if some changes can be made. So we shall watch with interest as to whether the final version of the legislation is substantively any different to that we've been talking about tonight. Thank you so much, everyone, for joining us this evening. We hope it's been useful, and the details will be circulated, including slides, very shortly by our estimable marketing team. Thanks, everyone. Good night.